Okay, everyone, some new filings this week in Don Lemon's criminal case. Now, Don Lemon's attorneys didn't file, to their credit. Just a handful of the defendants didn't join in the filings, to their credit. Now, here's one of the filings, which was in the form of a letter to the judge complaining that there are too many redactions in the discovery material produced by the government. So, the government did produce a voluminous amount of discovery, apparently, but the defense says entire pages are redacted, so the defense can't even tell what it is. Now, Georgia Fort, one of the journalists, filed a motion for the same reason. She's attached examples. There are huge differences in the discovery rules governing civil cases versus criminal cases. The defense here is asking for disclosure of material that need not be disclosed in criminal cases, and it seems to me that the government just produced a completely redacted page just to indicate to the defense that it is a multi-page document. So, the filings this week ask the judge for a status conference to discuss the alleged improper actions of the government in producing discovery material that the defense considers to be overly redacted. And procedurally, I would say if the defense is unhappy with the government's discovery production, what they need to do is meet and confer with the government's attorneys, try to narrow the areas of disagreement, then file a motion to compel discovery with the court, then ask for a motion hearing before the judge. Now, here the defense has jumbled all those steps together in a letter to the judge and is demanding a status conference. Now, I believe what they're asking for is a motion hearing, but they haven't filed the motion yet. Let me go on to the substantive objections. Now, the defense says in the letter that after speaking with the government's attorneys, and I quote, the government did not intend to disclose the names or contact information for any witnesses identified or interviewed by the government. Further, the government does not intend to disclose the redacted information until it produces its witness list, which it has proposed to do 28 days before trial, unquote. Now, the government is legally correct here. What mistake is the defense making? They're relying on civil procedure instead of criminal procedure. The case is a criminal case. Now, what the government proposes to do is more than the government is required to do under the rules. Aside from the Brady or Giglio material, the government isn't required to produce prior recorded witness statements until after that witness testifies at trial. Then the defense is supposed to move at trial for production of prior statements of that witness in the government's possession or within the government's knowledge. Then the government is supposed to hand those statements over during the trial. Then the defense is supposed to ask for a recess, time to examine those witness statements before cross-examining that witness, okay? Now, those rules work whether the prior recorded statements are in paper form or, as in this case, video recorded interviews. The rules still only require that the defense be given a recess, enough time to examine the recorded statements before conducting cross-examination of the witness. Now, a recess during the trial could last several days, depending on how voluminous the prior recorded statements of that witness are. To avoid such delays after each witness testifies and before that witness is cross-examined, the court's general order, which it issued months ago, encourages the government to produce all prior recorded statements of testifying witnesses before the trial. And here, the government says it will produce them 28 days before trial. That's plenty of time for the defense to examine those statements and prepare for cross-examination of each witness without asking for a days-long recess after each witness testifies on direct examination. But the letter goes on to complain, and I quote, as to the many witnesses who the government does not intend to call at trial, the government apparently does not intend to ever disclose the redacted information pertaining to those witnesses. And the government is legally correct on that. In civil cases, that material probably would have to be produced, but in criminal cases, unless that material is Brady material, that is to say, exonerating, could be used for impeachment, or could reduce the potential sentence to be imposed. Aside from the Brady material and the Giglio material, there's no obligation to disclose information that's part of the government's own investigation of the case. Now, that's why, in my view, the defendants should be required to follow the procedure for motions to compel discovery. Instead of just pointing to a redacted page and saying, well, the government should produce, the defense needs to articulate why the redacted page contains Brady material, or Giglio material. In other words, the defense needs to review Rule 16, which governs discovery in criminal cases. Now, if the redacted page doesn't match any of the categories of discovery material listed in Rule 16, they need to articulate what other reason there could be to require the government to disclose it. And obviously, the judge doesn't want to hear that the defense needs the material to defend themselves against a civil case that's been filed by a churchgoer. I mean, this case is not a civil case. The judge hated that argument, which some of the journalists used last week in their oppositions to the government's request for a protective order. Now, civil cases are governed by different rules, and the protective order that was entered says the discovery produced in this case can only be used in this case, in any appeal, and for no other purpose. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.